So a law gets passed that demands complete transparency in the Epstein case. Simple enough, right? Well, a bombshell letter to Congress is now claiming the Department of Justice is actively defying that law. Today, we're going to break down these really serious allegations of a cover-up at the highest levels.
The letter to Congress kicks off with this, and wow, it's a powerful statement. This isn't just rhetoric. It's a demand for unfiltered truth, not just for the public, but specifically for the survivors who've been waiting for accountability for decades. You could say this is really the moral heart of the whole conflict.
Okay, so before we get into all the accusations of a cover-up, let's just take a step back. It's important to understand what the Epstein Files Transparency Act was actually supposed to do. What was the original promise here?
And the law itself is incredibly direct. It's a mandate. And I mean, it's not a suggestion. It's a direct order for the Department of Justice to release all unclassified records connected to the Jeffrey Epstein case. No ifs, ands, or buts. No exceptions, no loopholes.
So why create this law in the first place? Well, it was really built on 4 key pillars. First, public accountability. The idea that the powerful people in Epstein's network should finally face some real scrutiny. Second, government integrity. A chance to restore some public trust. Third, and this is so important, truth for survivors, the simple justice of full disclosure. And finally, preventing institutional failure, so we can understand how the system failed so badly and make sure it never, ever happens again.
But here's the thing. According to the letter sent to Congress, that promise has been broken. And this brings us right to the center of our explainer today, the allegation that the Department of Justice hasn't just failed to follow the act, but has been actively defying it.
This right here is the core accusation: narrative management over the law. The claim is that the DOJ has been way more concerned with controlling the story and managing public perception than with simply following a direct legal order. This accusation pretty much frames every specific failure they talk about next.
So let's look at the specific violations they're alleging. First, a missed deadline. The law mandated a full release of everything, not a partial one. Second, some major omissions. A crucial 82-page memo and a 60-count draft indictment, a document that could reveal who prosecutors were originally planning to charge, were allegedly just withheld. Third, prohibited redactions. The letter claims information was blacked out not for legal reasons, but for political sensitivity. And finally, a total lack of justification. The act required a written explanation for every single redaction, and the DOJ allegedly provided none. Zero.
And when you dive deeper into those redactions, the claims get pretty explosive. It alleges that FBI personnel were actually instructed to flag and black out any mentions of Donald Trump. It also claims that victim-level protections were given to wealthy and politically exposed persons. That's a term for people in prominent public jobs, like politicians or executives. Essentially, the very people the act was meant to hold accountable.
And the allegations don't just stop at redactions. According to the letter, over a single weekend, a number of documents simply vanished from the public website. At least 16 of them, including a photo of Donald Trump taken from Epstein's residence, were there 1 minute, and then they were gone the next, with absolutely no explanation.
The law also required a modern, searchable database for researchers and the public. But instead, the letter alleges the DOJ just provided a data dump of old, recycled court filings that were already public. It just served to make the release look bigger without actually providing any new information.
So this alleged pattern of non-compliance brings us to our final section, the demand for action. What are the authors of the letter actually asking Congress to do about all this? The argument really hinges on a core principle of American government, the separation of powers. The letter argues that the Department of Justice, which is part of the executive branch, can't just be allowed to ignore or cancel out a law that was passed by Congress. If they did, it would set a really dangerous precedent and undermine the entire legislative process. And so they're proposing 3 escalating actions for Congress to take against the Attorney General. First, issue subpoenas to compel the release of the documents. If that doesn't work, step 2, initiate contempt of Congress proceedings. That's a formal declaration that an official has obstructed the work of the legislative branch. And as a final and most serious step, they're demanding Congress begin impeachment inquiries for willfully violating a federal statute.
And so we're left with a question that goes far beyond just this specific case. It's a question about the very nature of accountability and power. When a law is passed specifically to bring secrets into the light, what does it mean for our institutions, for justice, and for survivors, when the official response is alleged to be redactions, omissions, and just silence?